Episode 3, Overview of Intentional Torts, the Prima Facie cases for the 5 traditional intentional torts. As described in Episode 2, tort causes of action can be categorized into 3 main types of liability. Intentional torts are civil wrongs caused more or less deliberately by the tortfeasor. Negligence, an unintentional tort, is a civil wrong caused by the defendant's carelessness or failure to take reasonable precautions. And finally, under certain circumstances, courts impose strict liability even though the plaintiff cannot establish that the harm was caused deliberately or even that it could have been avoided by the exercise of reasonable care. In this episode, we're going to give you an overview of intentional torts, focusing on the 5 traditional intentional tort causes of action: battery, assault, false imprisonment, trespass, and conversion. We'll cover each of these in more detail in future episodes. We'll also introduce a few additional intentional torts in later episodes, including intentional infliction of emotional distress, also known as outrage, and defamation, also known as slander, and libel. Each of the 5 intentional torts covered in this episode is described in a section of the Second Restatement of Torts. For example, battery is defined in the Second Restatement, Section 18. An actor is subject to liability to another for battery if he acts intending to cause a harmful or offensive contact with the person of the other or third person, or an imminent apprehension of such a contact, and an offensive contact with the person of the other directly or indirectly results. This rule is a reasonably accurate description of the circumstances in which courts have imposed liability for battery. It introduces several distinct concepts. Courts typically described these concepts as the elements of the prima facie case. Different courts, or even the same court in different opinions, might refer to these elements using slightly different terms. The key is to master the basic concepts so that you can recognize them even when a court uses slightly different labels. Let's take the language from the Second Restatement and break it down into the basic concepts. Second Restatement, Section 18, battery. An actor is subject to liability to another for battery if he acts intending to cause a harmful or offensive contact with the person of the other or third person, or an imminent apprehension of such a contact, and an offensive contact with the person of the other directly or indirectly results. We can restate this in a way that's a little more straightforward. To hold the defendant, we'll use the shorthand D here, liable for battery, the plaintiff, we'll use the shorthand P, must establish 1. That D acted volitionally. 2. That D intended to cause a harmful or offensive contact. 3. That a harmful or offensive contact actually occurred. And 4. That the contact that occurred was caused by D's volitional act. We can simplify it even further using a kind of shorthand that judges and attorneys typically use. The prima facie case of battery is 1. Act, 2. Intent, 3. Harmful or offensive contact, 4. Causation. Note that there's some extra language we haven't dealt with under Element 2. Intending to cause a harmful or offensive contact with the person of the other, or a third person, or an imminent apprehension of such a contact. That language is describing the doctrines of person-to-person transferred intent and tort-to-tort transferred intent. We'll deal with those later in the next episode. we can use the same kind of shorthand to describe the prima facie cases for the other intentional torts. Second restatement, Section 21, assault. An actor is subject to liability to another for assault if he acts, intending to cause a harmful or offensive contact with the person of the other or third person, or an imminent apprehension of such a contact. Notice that we have some of the same extra language about transferred intent that we'll deal with later, but setting that aside, and the other is thereby put, notice that we're using the blue color there, in such imminent apprehension. To hold D liable for assault, P must establish 1. That D acted volitionally, 2. That D intended to cause imminent apprehension of a harmful or offensive contact, 3. That imminent apprehension of a harmful or offensive contact actually occurred, and 4. That the apprehension that occurred was caused by D's volitional act. Or, in our shorthand, the elements of the prima facie case of assault are 1. Act, 2. Intent, 3. Imminent apprehension by P of harmful or offensive contact with P's person, 4. Causation. Let's take a moment to clarify the relationship between assault and battery in torts. An assault is where D causes the imminent apprehension of a harmful or offensive contact. And a battery is where that harmful or offensive contact actually occurs. So an assault can be like an attempted battery that's incomplete, but that caused P to be aware at some point that contact was imminent. For example, I point a gun at your forehead and pull the trigger, fully intending to shoot you. But, unbeknownst to me, the gun is not loaded, and so no contact occurs. Assuming that you were aware that I was pointing the gun to your head, I did cause you to apprehend an imminent contact. So an assault has occurred, but a battery has not. Or an assault can be like a fake-out, where I point a gun at you that's not loaded and pull the trigger. I know it's not loaded, but you don't. So you think contact is imminent. Keep in mind, though, that attempts are not torts in their own right, in the way that attempted murder is a crime in itself, unless the attempt amounts to a different tort, like assault. Now we'll cover the other intentional torts more briefly. False imprisonment is confinement of a person to a limited area. For example, if I'm robbing a bank and I point a gun at bystanders, telling them to lie down on the ground and not move, that's false imprisonment because I am preventing them from moving or leaving the bank. If they see me point a gun at them, then there's also an assault. To hold D liable for false imprisonment, P must establish 1. That D acted volitionally, 2. That D intended to cause confinement of P to a limited area, 3. Confinement of P to a limited area without P's knowledge of a reasonable means of escape actually occurred, and 4. That the confinement that occurred was caused by D's volitional act. So, the elements of the prima facie case of false imprisonment are 1. Act, 2. Intent, 3. Confinement of P to a limited area without P's knowledge of a reasonable means of escape, 4. Causation. Trespass is an invasion of someone else's property interest. Trespass to land is an invasion into someone else's land. For example, if I go hunting on private property without the owner's permission, that is trespass to land. Trespass to chattels is an invasion upon another kind of property, like a car or a photo album or an animal owned by the plaintiff. For example, if I throw a rock at someone's cow, hitting it but not killing it, that's trespass to chattels. To hold D liable for trespass, P must establish 1. That D acted volitionally, 2. That D intended to go to a specific location or to cause contact with a specific piece of property, 3. That an invasion upon land or chattels of which P is in possession or is entitled to possession actually occurred, and 4. Causation. So the elements of the prima facie case of trespass are 1. Act, 2. Intent, 3. An invasion upon P's interest in land or chattel, 4. Causation. Conversion is a more serious invasion of someone else's property interest in chattel. For example, if I throw a rock at someone else's cow, hitting it but not killing it, then that's trespass to chattels. But if I shoot the cow and kill it or seriously injure it, then that's conversion. To hold D liable for conversion, P must establish 1. That D acted volitionally, 2. That D intended to cause a serious invasion of P's possessory interest in chattel, 3. That a serious invasion of P's possessory interest in chattel actually occurred, 4. Causation. So, the elements of the prima facie case of conversion are 1. Act, 2. Intent, 3. A serious invasion of P's possessory interest in chattel, 4. Causation. You may have noticed that in our shorthand version of each of these causes of action, the act, intent, and causation elements are the same. It's really just that third element, the particular consequence, that's different.